Friends, Namaskar. You are welcome to this show. And today in this series 21, we are going to talk about the new criminal laws of India. You are aware that in 2023, the Indian Parliament has wiped out the old and archaic British regime criminal laws of India. Those were Indian Penal Code of 1860, the Indian Evidence Act of 1872 and the CRPC of 1998, which was amended in year 1973. These three laws have been abrogated, and now from 1st July 2024, the three laws, namely the Bharatiya Nyaya Sanhita 2023, which has replaced Indian Penal Code 1860. The second Sanhita, the name is Bharatiya Nagrik Suraksha Sanhita of 2023, that has replaced CRPC of 1973, and the Indian Evidence Act of 1872 has been replaced by Bharatiya Saksh Adhiniyam 2023. The beauty of these three laws: number one, they are Indianized. We have decolonized the British ruled criminal laws. They were actually designed to serve the colonial purpose, to suppress the Indian folks. So these new laws, they are Indianized, they have adopted Indian culture, and the most important point which everybody should acknowledge, that the shift from punishment to justice. That is the reason why this penal code has been termed as Nyaya Sanhita. Further, in Criminal Procedure Code, the procedure has been converted into Nagrik Suraksha. So these are few glaring points. So let us begin with what kind of changes have been made. So today I will provide you the general characteristics, the highlights of these three laws, what are the aims, why they have been drafted, why they have been enacted, and in detail we shall be discussing in this series 1 about Bharatiya Nyaya Sanhita 2023. So there will be three series, friends. Today we are taking up the series number 1, Bharatiya Nyaya Sanhita. In number 2 series, we will be talking about Bharatiya Saksh Adhiniyam 2023, and in series 3, which shall be the final one, we shall be discussing in due course of time about Bharatiya Nagrik Suraksha Sanhita 2023. So today in series 1, you are going to watch the discussion on Bharatiya Nyaya Sanhita. Thank you. Let us move ahead. So Bharatiya Nyaya Sanhita, the new criminal law series 1. As I told about the nomenclature of these three laws, which have been enacted by Indian Parliament in 2023, these are Bharatiya Nyaya Sanhita, we can call it BNS, then Bharatiya Nagrik Suraksha Sanhita BNSS 2023, and Bharatiya Saksh Adhiniyam BSA 2023. The another important feature of these three laws are that they have not been translated into other language like English or otherwise. So they are as it is being written in English translation. The date of implementation, as I mentioned, that though Indian Parliament has enacted them in 2023, but they came into operation from 1st July 2024. However, the pilot project was conducted in Chandigarh Police. Program Secure Society Developed India from Punishment to Justice was addressed by Honorable Prime Minister on 3rd December 2024. In fact, I was also invited for that program, and I had occasion to listen our Honorable Prime Minister Sri Narendra Modi ji and Sri Amit Shah ji, Honorable Home Minister of India, on that occasion. So they have given illustrative, reasoning behind these three laws in brief. Now, these are the major observation on new criminal laws, the objective and vision. So it is from colonial to citizen-centric. That means decolonization to Indianization. As I already mentioned, there is a shift from punishment to justice. And in other words, generally the society observe retributive justice. Retributive means that eye for an eye, tit for tat. But here the shift is from retributive to responsive justice. We want to restore peace and tranquility. We want to restore the peace of the victim. That is why it is not merely punitive. It is corrective. It is responsive. So that is the difference between this justice system compared to Indian Penal Code of 1860. The other feature of these three laws are the simplification. The language have been used in a simple manner. The jargons, the Latin words are tried to be removed so that a common man can simply understand the language. Otherwise, legal language are generally jargonized. Then protection of individual, that is right-based criminal justice system. CJS means criminal justice system, you are aware. Then incorporation of contemporary issues. So many issues we will discuss in due course, like use of cyberspace, cyber technology, like videography, then conducting searches and all. So many things we will discuss in due course. Then efficiency has to be increased. The speed is the need of the hour. So with these things, these are victim-centric. Victim compensation, that victims should be made aware about the development of investigation, then trial and all. Then technological modernization and scientific enablement. Police have been made accountable, transparent and responsive. Their professionalism has also been taken care of so that they should be professional. They should be public-centric. They should bring happiness into the society. They should not be punishment-oriented. The rationalization of court, lot of things have been done in the due course. The purpose is speedy justice. That is very important because huge number of cases have been piled up in the courts. So that is another area which addressed by these laws. Then continued gaps, although lot of cares has been taken, but still there is always scope for improvement. So people says that marital rape, sodomy, like many such issues should also be incorporated, and I believe that in due course they will be taken care of. Now let us begin with BNS in little detail. So it is easier for anybody to understand in a comparative chart, in a comparative table. So this is a matrix. The simple way to understand the origin and intent. In IPC, as you know, it was actually in 1860 when this 1856, the mutiny was subsided by British government. After that, they thought to make stringent law, and probably IPC was promulgated on that note. So it was enacted by Britishers with colonial legacy to serve the purpose of the British rulers. It was not meant for the public at large in India. BNS, on the other hand, it is indigenous law oriented with Indian culture, ethos, and focus shifted from punishment to justice. We have already discussed these things. Then structure, if we see the framework, then there are 19 chapters in IPC, and there are 511 sections encompassed in those 19 chapters. However, BNS has 20 chapters, but sections have been reduced and they have been 358. The sedition, which was a matter of discussion and discourse since I think many years, because it served the purpose of the rulers at the time when in 1860 the IPC was enacted. So that has been removed, the sedition has been taken out, and now section 150 has been introduced by the name replaced with act endangering sovereignty, unity and integrity. So sedition has been abrogated from the Penal Code, you can say, and the replaced word is the act endangering sovereignty, unity and integrity of the state. So that is most important. In sexual offense also, section 375 were focusing on women only, that was gender specific. However, the content of this section has been taken in section 63. However, there are a lot of changes we will discuss. Mob lynching was never been the part of Indian Penal Code. However, this becomes very important in recent past, in couple of years. So, section 103 explicitly deal with mob lynching. There are two parts in mob lynching. If somebody is being killed, then different sections. But if somebody has been brutally injured, then the section will be different. We will discuss in little more detail. Likewise, terrorism and organized crime, which is the most, you can say, sensitive area, which is being most dangerous and diabolic crime, terrorism and organized crime. They were not specifically dealt by Indian Penal Code. However, section 111 to 113 encompass these particular crime in detail. Then community service as punishment. It was not at all in IPC. However, it has been introduced for the petty offences. We will discuss that what kind of punishments are there. Death penalty, life imprisonment, term imprisonment, then fine, and now this is a new entry into the list of punishment. Then bestiality, it was the part of section 377. You are all aware that was discussed in Navtej case. You must be aware the series of cases were there. However, it is retained only bestiality but decriminalized consensual same sex. So lesbian and other things, you might be aware of this development, and now only bestiality has been retained, but consensual sex between the same sex individuals have not more criminalized. Then digital and cyber crime, not adequate provisions in IPC, because at that time probably the cyber issues were not at all there. They have been properly addressed in the new laws of BNS. Offense against women and children, there were limited provisions, although they were defined. However, the scope has been expanded, like acid attack, child sexual abuse. Child sexual abuse have been dealt in POCSO itself as separate and a special law of 2012. But these offences have been dealt under BSA as well. Now, the organized crime, no specific categorization in IPC, but there have been well-defined provisions with punishment provisions in BNS. The hate crime, again, a big challenge for law and order. I am a police officer, I can understand how hate crime and communal violence destroy the peace and tranquility of any area. So, in BNS, more clearly defined, for example, in section 113 on terrorism by organized groups. So, there are so many, terrorism, then organized crime, 111 to 113 in BNSS. These are very, relevant sections introduced in BNS. Then attempt to suicide, it was punishable under 309, but however it is no more any offense. So that's the beauty of this, because the person who commits suicide can no more be punished under 309. However, if it is a failed attempt of suicide, then the person is considered to be accused, despite the fact that he has some mental trauma and he is an actual victim of mental distress. But unfortunately, in IPC, he or she was considered as accused. That was the very pitiable situation that has been rectified in the PNS under section, defined sections. Marital rape, the exception was there in 375, the similar status, but it has not been well defined, and this is probably people has the other you can say ideology, those who say that marital rape should be punished, although it is a debatable issue, but I think BNS, considering the cultural percept, cultural forces operating in the country, they did not find a suitable time to introduce it, maybe in due course, of course. So sedition, it has been replaced by section 150. Let's see what it is. Sedition under IPC. What was the meaning of sedition? Use of words or action intending to encourage people to act against government. Here it was not state, it was government. Just understand that. Section 124 IPC was colonial era of handling sedition. Why they have kept sedition? Because they want to protect their government actually. They were least bothered about the state. The British government was more important for them. That is why sedition has kept under 124A the act intended to encourage people against the government. That was the point. So now in BNS 124A is no more. Yeah. So let's see the sedition provision in IPC and BNS. Although sedition word has been removed, but what are the changes made? So let's see in the matrix format. The section in IPC was, I already mentioned, section 124A, but now it is 150. The name has been changed. Earlier it was sedition, now it is acts endangering sovereignty, unity and integrity of India. So shift is from government to state. Now it was earlier British government, now it is India. So that is the change. Then definition, any word spoken or written, sign or visual representation that bring into hatred or contempt or excite dissatisfaction against the government established by law. Here it is against India, the sovereignty, the separatist activity, rebellion, armed rebellion, attempt to excite secession and things like that. So now the focus is from government activity to state sovereignty. That's the beauty of section 150 of BNS. Then key element, if somebody asks you what are the key element of sedition, so hatred or contempt against government again, then dissatisfaction include disloyalty and enmity, then maybe through word, sign or representation. So these are the basic ingredient, and always understand when you are studying any section or provision of law, always dissociate it or dissect it into the ingredients to better understanding. So in section 150 the ingredients are encouragement of secession, rebellion or activity like that. No limit to speech alone. Targets act against sovereignty. So that is actually for the state purpose. The punishment is life imprisonment or 3 years with fine. Here life imprisonment or 7 years or fine or both. So little more, up to 7 years only. Earlier it was up to 3 years. So offense against state. Yeah. Special provision. The offense against the state. These are very important because such crimes affect the sovereignty and integrity of the country, the security of the state and people at large. It threatens the constitutional government and it disturbs public order. That is why such laws are very, very necessary, which has encompassed under section 150 of BNS. Now, offense against state, just see the old law and new law. Here there are the old sections. I have just compiled the entire gambit of the crime against state. Section 121 to 123, waging war against state, where sedition was also part of it. Now the section 149 of BNS. Then 122, collecting arms to wage wars. Here it is 150, which already we have discussed. Then section 123, concealing intent to wage war, that has been taken care in section 151. Then section 124, assault on president or governor, assault, that has been incorporated in section 153 of BNS. Section 153A and 153B, they are related to promoting enmity between groups. So group conflict within the country, that has been taken into account under section 194 to 195 of BNS. Now let's come to mob lynching. Friends, mob lynching is a very threatening for any law and order situation. I think it depresses the psyche of the people at large. It is spread as if there is lawlessness. So I think any police officer, any state governance always have very heavy hand to control mob lynching, crowd or whosoever the actors for mob lynching. This is a very, very horrendous crime, I think, in my opinion. Section 103, this is a new entry in our new set of criminal law, particularly in BNS 103. Mob lynching define and ingredients. The definition of mob lynching, it is extrajudicial killing or injury, causing injury to the person, or violence you can say. It is a form of collective violence. Collective means it cannot be done by one person alone. It has to be collective intent as well. Where a mob, under the pretext of administering justice without trial, they think that they are doing justice something. They become Supreme Court by their own whims and fancies. They execute a presumed offender after inflicting. So these are the basic things which I have underlined under this definition. Now let us see the issues and pretext. Sometimes they feel, oh, we are doing something great for the society. The moral vigilantism. So vigilantism means nigrani, like they are watching something. They are the watchdogs, self-proclaimed. Of course, they are illegal activities, but they claim so. So they perceive threat to cultural identity, rumors and fake news. They are the causative factors. Sometimes it happens that this happened, that particular animal has been slaughtered, and things like that. Committed by vigilante group or mobs, trigger issues, cow protection, race, religion, sometimes the female marriage or something like that, in inter-religion, interfaith or something like. So there may be so many factors behind it. Live instances, there are n number of live instances written on Google if you do that. Muhammad Akhlaq in Dadri, around 10 years back in 2015. Pehlu Khan in Alwar 2017, and the list is exhaustive. I have just given very indicative names. Then the facts relative to mob lynching. The mob lynching factors are the triggering factors. Cow slaughter may be sometimes the rumors like that. Theft accusation that somebody has stolen something. Then mob may get collected and they get violent and kill the person. Then child kidnapping fear, religious bias, and so on and so forth. The actors are, as I mentioned, there are different type of vigilante in the society, cow vigilante, religious vigilante, and caste vigilante, so many factors. The self-styled protector of the society. Their local moves, sometimes the goons also become part of it. Then medium information, there may be the digital things, WhatsApp, Facebook, temple announcements, mosque announcement, and so on and so forth. Victims, often marginalized groups or minorities. Those who are very marginalized, they are mostly being lynched. The blame and accusation, they frequently accuse of delayed action, bias or collusion. Legal gaps, there was no specific anti-lynching law until recently. BNS has addressed it particularly in a specific section. The provision under IPC, earlier, how the mob lynching, that was, although there were sections, but they were scattered sections. Say, for example, during lynching, a person is killed, then section 302, section 307, 324, etc. for body offense. It may be death of the person, it may be some injury, some violence like that. Then 147, 148, people might be knowing for writing purpose because a lot of people got collected as a mob, and these sections are related to rioting, creating some riot by using weapon. 149, certainly when there are more than 5, it becomes unlawful assembly. So 149 is also very important, and I think you might be remembering the difference between 149 section and 34. That's a very significant. Sometime I will deal with it. 120B, criminal conspiracy, because they are doing with the criminal conspiracy to do something which has been conspired, to kill somebody, to beat somebody, to create some violence, to create land order situation. So it is a criminal conspiracy also to be inflicted upon the accused. The SC/ST, the Prevention of Atrocity Act, if victim belongs to such category. In case the victim belongs to SC/ST category, then of course this act also get attracted against the mob lyncher. The ingredient of 103, because 103 is the section, when a group of 5 or more, definitely they are actually unlawful assembly. 149, acting in concert. Concert means in a group with common intention. Intention is very important, common intent, right? On the ground of race, caste, community, sex, place of birth, language, personal belief, or any similar ground. It may be some religious cause also, so there are multiple factors behind it. Punishment, each member of mob, whether he directly participate in that violent act, but if he or she is a part of that mob lynching mob, if one is the member of that mob, the unlawful assembly, that is enough to punish. And they have equal onus. The focus is on identity-based violence, group criminal liability, debtor hate motivated vigilant justice. Now, as I mentioned about section 103, this is for murder mainly, but if there is grievous hurt, then the section 117, subsection 4 will get attracted. When a group of 5 acting in concert on the pretext or something like that, they are the common thing, but here it is causing grievous hurt, then section 117, subsection 4 will get attracted, and the punishment is up to 7 years. Mob lynching definition and ingredient, that has been very well defined in this case. Tehseen S. Poonawalla versus Union of India in 2018, the Supreme Court referred to this crime horrendous act of mobocracy. Like democracy means the elected government by the people, but here they try to grab the power there by mob. So that is why it is called mobocracy. The directed state to set up designated fast track court so that the accused or the culprit should be taken to the task without delay. Setting up a special task force for intelligence gathering. They have also directed for paying victim compensation, accountability officials for failing to prevent mob lynching. So that means the accountability of police force and administration local. State having special laws against mob lynching, several states, I have given some name, West Bengal, Rajasthan, Manipur, Jharkhand. Then I have just seen, although it is not part of our discussion in BNS particularly, but I thought what happens in other countries. So I just mention about few countries like United States. They took over 120 years to enact anti-lynching legislation. Don't think that this problem is only India. Even US, UK, and all countries suffer with this syndrome of mob lynching. The Amity Till Anti-Lynching Act. The Amity Till was a boy of 14 years. He was African American who was lynched in Mississippi in 1955. And in the remembrance of that boy of 14 years old, this act was enacted in 2022. You just see how long it took to US to enact the law. In South Africa, if we see, it is referred as neck lacing during apartheid area, dealt under general criminal laws. There is no specific law in South Africa. and in UK also the same scenario. Now, let us talk about community service, my dear friend, as punishment. In our BNS, community service has been added as a type of punishment. So what kind of punishment are there in our laws? Let us see. So these are the types of punishment: death penalty, imprisonment for life, imprisonment for rigorous or simple nature, maybe term imprisonment you can say, then forfeiture of property, fine, and now this is the new entry, community service, that has been added under section 4 of 4 subsection F of BNS, that is retrospective justice. Restorative justice, basically to restore the peace and tranquility, the peace of the victim. It is not retributive, it is restorative. The nature of crime for community service: in those offences which are less serious, non-violent, and socio-legal in nature. What type of community service can be given? There is no specific listing what type of service, community service, but these are certain that depend on the discretion of the court, and these are something like cleaning of public place or government building, plantation, environment restoration, teaching, caregiving, administrative support, assisting NGOs, traffic management, sometime library management, sometime many other type of activities. So it depends actually on the wisdom and will of the Honorable Court to provide the type of community service what one has to do. The community service as punishment, let us see the legal scenario. Section 79(2) in BNS, it talks about theft below rupees 5,000. So if theft is below 5,000, the person may be awarded depending upon the circumstances, not necessary for everyone, but maybe for the first timer, the court may think fit for punishing him by community service. The imprisonment up to 1 year, fine or community service. Okay. For section 85, misappropriation of lost property. Suppose you find something on road and you have used it. Later the owner of that property is demanding, so and you are just trying to misappropriate that. So in that case, fine or community service may be awarded. Likewise in section 112, subsection 2, defamation in certain contexts, not in all. There also, if it is the minor kind of defamation, not grievous. 126, non-payment of maintenance to the wife, to the children, to the parents, or so and so forth. There also community service may be awarded as punishment. 255 section of BNS, public servant refusing to do duty. So there also community service may be awarded. So here the discretion of the court to impose community service where appropriate. So the discretion lies with the court. Now the gender related provision. What are the gender related provisions? Let's see, dear friends, about this. Gender justice. This is transformative approach. Because you know that gender itself has its own connotation. We cannot treat all genders at all time in the same manner. So that is why gender sensitivity is very, very important approach. The sexual offense, retention of IPC section 375, if you see 63 of BNS and compare with 375 of IPC, there are a lot of identical situations. However, they have recognized in this BNS cyber-enabled gender crime, because at that time when IPC was promulgated in 1860, there was no cyber crime, no internet and other cyber technology. So they have expanded in BNS scope of sexual offense such as cyber stalking, cyber voyeurism, identity frauds, use of digital devices, social media for sexual abuse, and so on and so forth. We are all aware, sextortion, like sexual offense online, pornography, what not is happening around. So this BNS is very aptly dealt all those cyber related crimes. clear strengthening child protection, of course, clear and stricter punishment for offence like gang rape, custodial rape, child sexual abuse, and so on and so forth. Bestiality retained, however, homosexuality decriminalized. We have already talked about. Then the criticism, no marital rape exception removed. Graded punishment policy. This is again a very unique feature. What is graded punishment policy? It is higher punishment for CSA, gang rape. CSA means child sexual abuse, gang and or custodial rape, then trafficking rape, etc. That means that the grades are there, that what kind of level of crime actually. So that depend actually graded punishment policy. Enhanced protection, pregnant women, minor, women in custody, they have been kept under protected group of people. So gender specific, if I compare with IPC and BNS, then certainly this table will help you. Like rape definition, it was earlier in 375, now in 63. Punishment for rape 376, then 64. Minimum 7 years was there. Custodial rape, stalking, voyeurism, all things have been written here. I don't want to repeat again and again. You are well aware. We will share these PPT also. You can go to my YouTube channel. There you will see it. Otherwise, that will also be available at ResearchGate. In case you don't find easily, then you can send your mail number or mail ID. Then we will share with you. Okay? No, don't worry. These are the continuation. The trafficking, prostitution of women, 370 to 370A. Now it has been kept under section 140. Abatement of suicide by a woman, child sexual abuse, material. This is something very important. Child sexual abuse related material like pornography material, sometime in the printed form, sometime on the online, and that material is very, very dangerous for the development of the children. So that has been taken care. Now the pregnant woman causing miscarriage without her consent is also an offence. Earlier it was there. Then maintenance related enforcement, although it is CRP provision, but in BNS and BNSS both have the provision how to implement the maintenance related, whatever compensation or anything has been awarded. Then gender neutral inclusive language. So these are very important. Earlier it was talking about man, he, but now it is gender neutral, the person, individual, like that the words have been used. The technology and digital era. Now, without incorporation of digital technology, I think any law is incomplete, and so is with our BNS. So, lot of technological intervention have been recognized and introduced properly. Terminology modernization, words like communication, device, computer resources, electronic communication, cyber fraud, these are very new terms in the recent past only. That's why they have been well accommodated in the new laws. Recognition of cyber crime, something like identity theft under section 67, cheating using computer resource section 68, cyber trespass, unauthorized access 69. We all get victimized by these sections, these provisions of crime, and the law, particularly BNS, has identified them and especially cater them, especially punish them under different provisions of law. Digital evidence and data protection, they have been linked with Bharatiya Saksh Adhiniyam. So BNS and BSA and of course BNSS, they are all putting together, they address well these issues. Harmonizing with global norms such as UK Online Safety Bill, US laws, CSAM. Why it is very important, the harmonization? Because the online business, online crime or online transaction whatsoever, they do not stop with the geographical boundaries. That is why you have to sync your cyber space legal framework with global template. So that is the need of the hour, and India has taken this step very aptly with right time. That's what I observe. Cybercrime, if we see particularly what are the cybercrime, these slides will help the students, the faculties, the professionals, those who want to upgrade their knowledge in a systematic manner. Suppose you want to understand what are the cybercrime under BNS particularly. So you can just have this piece of slide. The single piece of slide will provide you sections, the offenses made out, and what are the key details. So these are sections like 67 identity theft, 68 cheating using computer source, 69 cyber trespass, 73 publication or transmission of obscene material, 74 against CSAM, child sexual abuse related material, then 93 stalking using electronic means. These are mainly using, these days the females are very much victimized by stalking and voyeurism, because earlier you need to be the physically present, but online everything is open, the system is open, and you are watching a woman activities. You are stalking someone, right, knowingly and unknowingly by the victim. So these are the real challenge for the privacy rights actually. So our BNS has addressed it very well. 110 online criminal intimidation. Now let us see victim-centric approach. This is the beauty of BNS 2023, that victim has been kept in the center stage. Earlier victim was just like one of the witness, not more than that. What happens to the case? What is the fate of investigation? The poor victim was not at all aware. But now it is matter of right. You have to tell him or her what is the fate of the crime she or he got registered. So that is the important issue. There is a very, what is the victim-centric approach? Let's understand first what it is. It ensures rights, dignity, safety and participation in all stages of serious. Suppose crime happened with me, and if I am not aware, I am not being made part of what is happening, it is not a participation in any case other than just mere testimony in the courtroom. I think it is gross injustice. So that injustice has been addressed, and now victim is center focus for the criminal justice system. Then empowerment to seek justice, procedural fairness, human face and balance between the right of accused and the victim. Then enabling access to support system and victim protection. We have full-fledged Victim Protection Act in place. Empowering to heard victim voice in proceedings. You cannot just done away with that we do not know about what a victim understand, what victim said other than her or his testimony in the courtroom. No. Now victim is the central point. You have to understand this very well. The victim compensation and restitution, to bring him or her as victim in the streamline of the development. Then reduce secondary victimization. The secondary victimization, my dear friend, means that suppose there is a rape survivor. The society actually make her ostracized, make her mockery. If somebody goes to classroom, people have the different behavior. In the family itself, there are instances that family has abandoned, husband has abandoned the rape survivor. So that is a pathetic situation. So they need to be dealt with due care and attention, with compassion, with sensitivity. That's the beauty of this thing. It accelerates that sensitivity level. The statement may be recorded digitally. There need not to present all the time there. Suppose there is some threat, the victim may not like to come, so their statement can be recorded digitally on video recording. Time-bound investigation, yes, 90 days. We will tell about little more. And trial in 2 years. So investigation, you have to complete in 90 days. Exception may be there. And trial, not more than 2 years. So that is the timeline provided by the law. Victim impact statement in sentencing. Victim will also made part when the judgment is on punishment is declared. Like I already mentioned last time in one of the video, that judgment has two parts. One is determination of guilt, where the conduct of the accused is not at all considered. However, once a person is held guilty, then the next stage is determination of punishment. Here, the conduct of accused is very much into consideration. Suppose a person is first-timer offender, then he will be dealt leniently for punishment. But if a person is habitual offender, have committed so much of crime, then his quantum of punishment will be much, much, much higher. Then victim's right to appeal against discharge, acquittal, inadequate sentence. You just see, this is the important point. Earlier only state on behalf of the social contract theory we have talked in very recently in one slide or in one video, that appeal right was only against the state, because state is the parent patrie. So state can go only for the appeal, but no. Now in VNS, victim also has right to go for appeal in case of discharge, in case of acquittal, in case of inadequate punishment. So this is the enabling right, access to justice to the victim. The special provisions are also there, my friends, and they are immunity for armed force and public servant. I think you will believe that armed force, because they are the protector of the nation, they all protect us. Similarly, the public servant, they commit mistakes also sometime by knowingly. Of course, if they do, sometime they mostly do unknowingly, but if they do knowingly, that there is, of course, there is a provision of punishing them. But there is a kind of immunity that is very important. Otherwise, people will not, commence their duties. They will reluctant to get punished otherwise. So this protection is very important. Protection against vexatious or frivolous prosecution in course of official duty, like in disturbed area, counter-terrorism zone or conflict operation. Not absolute immunity. As I told, if you do wrong knowingly, then you are liable to be punished. So the immunity is not absolute. It is conditional. Conditional to the due care. Conditional to good faith. Your act should be in good faith with due care. That is the primary and minimal requirement for the immunity. Immunity cannot be used to shield deliberate or malicious act. Yes, this is the point. Act must be directly connected to official duty. Not that you are doing something else and in that coverage of your public figure, you cannot say that every act of mine is a public duty. It has to be directly connected with the designated duty your post is assigned to. It has been very well defined in this case law, Harihar Prasad versus Emperor in 1948. Then sanction is not required. Sanction for prosecution is very important part. Earlier it was in section 197 in CRPC and section 19 of PC Act, the Prevention of Corruption Act. However, it has been dealt in Prakash Singh Badal versus State of Punjab, and I always say that for better understanding, make habit to read judgments. No substantive change in old and new laws on Special Protection Act. The public servant immunity. This is the new law, old law. This is the comparison. Section 132, protection to armed force for act done to disperse unlawful assembly. No prosecution without sanction. Sanction for prosecution is very important. That had been kept in the section 131. Then section 197, I already told. 197 was very important for immunity of the public servant. Prior sanction required, and now it is in 218. Section 166 to 106, general defense. They are very popular general defense. I think when we were doing law, the general defense were very important and lot of questions being asked. So sometime we will do that. These are the protection against false or malicious prosecution. The causative factor for this attraction of this provision, malicious, the nature should be malicious, abuse of process, false evidence or complaints, wrongful arrest. These acts are misuse of police or judicial power. So this is also being dealt properly in our new laws. Now malicious prosecution, what are the sections in the old and new laws like BNS and BNSS, the new laws? These are the common, few are in BNSS and another in BNS. Like say for example section 78 of Bharatiya Nyaya Sanhita, it deals with false information to public servant, and same was in section 182. Likewise false evidence and fabricated document, false charge, compensation for accusation and all. So you can see this. If you want to read more, we will share these slides. Now simplification of language. So now we are very close to our concluding stage. Language. As I told, these three laws, the Parliament intended to make them simple, without any jargon, simple to the common man's language. So easier to understand for common folk, citizen-centric, simple without jargon, more accessible to victim. Then witnesses and law enforcement. Of course, sometimes all are not lawyers. We as police officers, we as forensic science experts, we need to know law in a very simple manner, and so is with these new laws. Free from colonial mindset, and they should not archaic. They are aligned with Indian Constitution because we implemented our Indian Constitution on 26th of 1950. So our every law must align, whether it was pre-colonial or post-colonial, it has to abide the broader framework, broader boundaries of our Indian Constitution. If anything goes out, then that will be ultra-vire. The gender neutral, he / his has been replaced by person, individual. As I already mentioned that it is not you can say it is asexual in nature. Clarity in definitions, lot of definitions have been clarified in a more systematic manner. So with this, now we conclude, friends. So this was our first part of this criminal law, new criminal laws, and the second part we shall soon declare, we shall announce. So be with us, and I sincerely request you once again to share this video, the channel, with others, and please subscribe. Your subscription motivates us to spread the knowledge. It is a pro bono media. It is pro bono approach. We are trying on the behalf of the institute UPSIFS Lucknow to enable you, to strengthen you as good and the best human being, and enabled the person, individual, the group, so that we can live together with happiness and tranquility, with greater order. With this, thank you very much once again. Namaskar, Jai Hind.